Hello everyone, my name is Nahida and today I will present and analyse a series of cases in New Zealand's legal history that address tiriti issues. The cases we will discuss are the cases of Parata and Bishop of Wellington, Attorney General and Ngati Apa, and the case of Takamore and Clarke. The three main tiriti issues that these cases address are Māori native title over land, Māori customary rights, and the cultural clash between state law and tikanga Māori. For the purpose of time, I will now turn to the first case. The first case we will discuss today is the case of Parata and Bishop of Wellington. In 1948, Ngati Apa tribe agreed to give some land to the Bishop of Wellington on the terms that the Angelic Church build a school on that land for the rangatahi of Ngati Apa tribe. In 1950, the bishop obtained a crown grant to that land, however, did not build a school on it. Consequently, in 1877, Parata, on behalf of the Ngati Apa tribe, took the Bishop of Wellington to the Supreme Court. Parata argued that the bishop was in breach of oral contract and should return the land back to Ngati Apa tribe. However, the Crown argued that there was no contract between Ngati Apa and the Bishop of Wellington because the land was gifted to the bishop by the Crown and not Ngati Apa. Parata then argues that Māori have native title over that land under the Māori Native Title Act 1865. Conversely, the Crown argues that Māori native title was extinguished when the land was gifted to the Crown. On the facts of this case, Chief Justice Pendergast makes three contradicting points by way of justifying his decision to exempt the Crown from any liability. On his first point, he states that treaties are a matter of state power and therefore within the Crown's prerogative and outside the court's jurisdiction. Secondly, he says that while the Māori Native Rights Act 1865 appeared to bind the Crown by the courts, that it could not have been Parliament's intention to bound the Crown, and so Chief Justice Pendergast continued to believe that any claims to native title remained solely within the Crown's prerogative and outside the jurisdiction of the courts. Thirdly, Chief Justice Pendergast states that when the British government arrived to New Zealand, there was no civilised government, and so reached the conclusion that Māori never had any sovereignty over the land and territory. In addition, Chief Justice Pendergast says in obiter dictum that the treaty was a simple nullity signed by primitive barbarians, essentially implying that any claim brought by Māori in relation to breaches of the Treaty of Waitangi had no standing because the treaty itself was nothing more than a piece of paper. After analysing the case of Parata, we find that this case does not only set one precedent, but sets three contradicting precedents. While the first two somewhat correlate with each other, the third precedent completely denies the existence of any valid treaty. We will now turn to the second case analysis. The second case we will discuss is the case of Attorney General and Ngati Apa. The case of Ngati Apa involved 8 Māori iwi from the northern South Island who wanted to undertake mussel farming on the foreshore and seabed of Melba Sound. The iwi applied to the local city council under the Resource Management Act to grant mussel farming activities. Their applications were denied. The iwi then took the issue to the Māori Land Court under the Te Turu Whenua Māori Act 1993 and requested the court to determine the foreshore and seabed of Melba Sound as Māori customary land. However, before the Māori Land Court could even consider the case, the High Court ruled Māori customary interests in the foreshore and seabed were extinguished when the Crown bought the adjoining land. Nonetheless, the iwi were able to appeal the High Court decision. On appeal, Chief Justice Elias overturns the High Court decision. Chief Justice Elias states that the Māori Land Court did have jurisdiction under the Te Turu Whenua Māori Act to determine whether the foreshore and seabed were Māori customary land. In addition, she distinguishes between customary rights and sovereignty and refers to specific legislation where customary rights have not been extinguished even where there is Crown sovereignty past the high water mark. The government was not happy with the Court of Appeal's decision, and so they immediately sponsored legislation which was then passed as the Foreshore and Seabed Act 2004. This effectively extinguished Maori customary rights in the foreshore and seabed. The new legislation was not processed well. There was both a domestic and international disapproval of the Foreshore and Seabed Act. This is evident from the Waitangi Tribunal report that identified a number of treaty violations, including violating treaty principles, and is also evident in the review of the Independent Review Panel that effectively repealed the Foreshore and Seabed Act. Consequently, the Foreshore and Seabed Act was repealed and replaced with the Marine and Coastal Act 2011. This act restored Maori customary interests in the foreshore and seabed as if the Foreshore and Seabed Act had never passed. Unfortunately, we have run out of time, so the only cases analysed in this presentation are the cases of Parata and Bishop and Attorney General and Ngati Apa. I'm looking forward to seeing all of you guys on Monday. Feel free to still ask questions on the cases of Takamore and Clarke. And thank you so much for listening to my presentation.